welcome to your Foley's Environmental Law Update web conference series. At this time, all participants are in a listen-only mode. Press star then 0 on your touch-tone telephone. As a reminder, this is being recorded. I would now like to introduce Mr. Dick Stoll. You may begin.
Okay, Mary, thank you very much. Today, welcome and thanks for being here. Today we're going to cover some recent Clean Air Act greenhouse gas developments. A lot of significant things have happened since the last time we did a web conference, if you were able to join us on that one back in February. There are going to be 3 of us speaking today. And let me go on. And we're going to have, in addition to me, we'll have Mark Temke, who's a partner in our Milwaukee office, and Brian Potts, who is a senior counsel in our Madison office. Today, what we're going to cover is first, Mark is going to be talking about the new so-called utility MACT rules that EPA just proposed in March, which are highly controversial. And then Brian is going to talk about the new cross-state rule that EPA just issued in final form last month. And he's also going to cover the, I guess the infamous Supreme Court case, the American Electric Power case, that the Supreme Court just issued in June. So again, we've had a lot of things happen since our last web conference. Then I'm going to cover a couple of things. If you recall, if you were here for our last web conference, we focused mostly on the new CSAPR boiler MACT rules that had just come out the day or 2 before our web conference in February. And there's been some interesting things that have happened, been a flurry of activity with regard to those 2 new rules. And then finally, I'm going to cover a DC Circuit case that everybody's been waiting for on some important MACT issues, and there's a little disappointment that the court ducked a couple of them, but I'll brief you on that just a little bit. Before we get going, just a few housekeeping things. There you see the number to call if you have any problems with your screen or your video or your audio. If you need audio assistance, there's the star 0. We're going to try to have time for questions at the end. That would be live when we can turn it back over to Mary. But in the meantime, if you see the Q&A menu up above, at any time you can type in a question, and we can't promise you we can answer all of them, but we will try to answer at least some of them. And we'll have your email addresses, so we'll go ahead and answer by email later if we can't address it during the presentation. You can maximize by hitting F5 or going to view and clicking full screen. You can print the presentation. There's the instructions there. There's a printer icon down below, or you can convert this to a PDF. Also, and by the way, we will apply for CLE credit, and then if you have any problem with that, contact Jennifer Bartz, and there's her email address. Also, I think most of you know this if you've been attending these, we will have this all available on the web within about 4 or 5 days. If you go to the Foley's website, you can find this and watch it again or download it or print it or whatever. And be sure and tell your friends who may have missed this that they can do that too. So let's go ahead and start with Mark now.
Thanks, Dick. We're going to start off with a discussion of the recent proposal and moving forward on the utility MACT rule, which has its interesting history and background. As we know, the MACT rules and the whole MACT history started with the 1990 Clean Air Act. That was in 1990, which is 21 years ago, and now we're still dealing with a lot of MACT issues. As Dick mentioned, the recent court case just on a number of these MACT principles. But for utilities, there was a deferral until a study came out as to whether or not MACT standards should be applied to utilities. Late in the Clinton years, before the administration moved on to the Bush people, there was a decision to proceed. During the Bush era, we came out with the CAMR rule, and this was also announced about the same time as the infamous transport rule of CARE. It seems as though utility MACT and transport rules seem to run together. During the Bush era, we moved down the path of trying to implement these rules, and both of them ended up being rejected by the DC Circuit Court of Appeals. So we're back now in the era of starting over. When the Obama administration came in, some people claim it was a tactic. Some others say it's just that the environmentalists wanted the rulemaking process to proceed, but a number of these MACT rules then became subject to lawsuits to promulgate them, which resulted in settlements, which resulted in hard dates for rule proposals and final rules to come out to actually move ahead. With respect to the MACT settlement, March 16th was the proposal date, and that date was met by EPA. And then we have a final rule date of November 16th with traditional MACT implementation schedules that would apply of 3 years or 1 additional year if there's the actual installation of controls, so you can get up to a maximum of 4. One interesting little statistic with respect to this is these rules are going forward at a time when some of the more recent studies are actually showing coal-based electrical generation decreasing, which is one of the first times that has occurred in the country. And as a country as a whole, 46% of the power production is based on coal as opposed to other forms. As you'd expect, this rule proposal is really aimed at the 1,200 coal facilities at a large number of power plants. In part, the end result of this rule should not be a tremendous surprise to anyone that's following the comments of EPA. Gina McCarthy in January at a conference that I was attending was very open and basically told the utility attendees that EPA was going to come out with a number of rules, and these rules were going to either require facilities to put on controls if they were uncontrolled or shut down. And she was very direct about it, didn't give the exact timing, but said the rules were coming. Obviously, utility MACT is one of those. In developing the MACT approach, this is something which we've seen in a lot of the MACTs that are coming out under the Obama administration, and that is an effort to follow the statute, do pollutant-by-pollutant analysis, build a legal defense under the statute, as opposed to applying more, quote, innovative approaches where you're using potentially averaging or fleet-wide type numbers or limits. And this is just a part that EPA knows there will be challenges to these rules, and they're trying to build a defensive position. I don't have all the numbers for the particular limits that are out there, but a couple of highlights. We're looking at a 91% control for mercury being required. We're looking at one of the items which actually was a plus for these facilities is workplace standards with respect to dioxin and furans, as opposed to setting numeric criteria, which had been done by some states under some state hazardous air rules. Instead, we're looking at optimal combustion. And EPA's view is that we will use typical control equipment, scrubbers, activated carbon, bag houses. Nothing out of the ordinary, in their view, can be used to meet these requirements. And of course, under all of the EPA rules these days, we have the number of construction jobs that will be created and the number of long-term utility jobs that will go with it. And I don't know whether 9,000 long-term jobs is because there's a lot of compliance activity that will take place, or we'll have a whole host of designated representatives have to file forms and be subject to potential enforcement actions. But 9,000 was supposedly the long-term jobs created by this rule. No, surprise, surprise, right? Controversy. With all of these rules, we've seen a large amount of controversy coming out. Early on, the Utility Air Regulatory Group, UARG, found a data error in the US EPA database, saying that the grouping of best performing plants upon which the numbers were then developed was too small. And that a larger base should have been used, and this is something that EPA is currently looking at with respect to what the final numbers would be. There's been congressional heat over this rule, all kinds of statements about costs, about electric reliability issues, several House GOP bills to delay or derail the rule, but the financial community, in looking at this rule and where EPA is at, has predicted that it's likely to proceed. depending upon how much you believe the financial community these days, given recent events. But at least that's their take on it. Some of the comments that have come in, because the comment period just closed on August 4th, groups like UARG and the National Rural Electric Co-op Association, those are generally smaller plants, are threatening lawsuits based on procedural issues or lack of support for claimed benefits. Larger facilities like Duke Power have asked for more time for required controls to come in. There was a recent write-up today even on comments submitted by some gas utilities. Those utilities generally burn natural gas, and one utility that's heavy into the nuclear field, and they actually were supportive of the utility MACT rule. Of course, they are in a different competitive position than those utilities who are primarily coal. And interestingly, Small Business Administration wants more innovation in the setting of the standards rather than the pollutant-by-pollutant approach, which of course runs contrary to the building of a legal defense by EPA. So I don't think that comment's going to go too far. On the flip side, you've got comments from the Edison Electrical Institute, which primarily is larger organizations, utilities, and they're looking at technical fixes that they view would be important, such as compliance date extensions, or if a plant's going to be shut down, that you don't impose a hard 3-year time frame to shut it down. You get a little more time. Those are some of the technical things that they're looking at. They're looking at greater subcategorization and startup and shutdown. As we know, under MACT rules, you have to have a limit, and they're looking at some type of workplace standard, but overall expressed a willingness to work with EPA on this. All right, just to wrap this up, what does this mean to me? Certainly at a utility side, it means planning with respect to repowering, shutdown, or controls. This whole series of rules, be it the transport rule, be it the utility MACT rule, are all saying utilities make a decision. We're going to put you on a time frame to do it. Whether or not 3 years is enough for purposes of going through rate commissions, looking at reliability, looking at load factors is a question, but certainly EPA has been mentioning this, and some utilities anticipated the action, already have that planning and rate commission approval underway. Look at project management of schedules, of vendors, of the regulatory approvals to achieve these dates will be key in any of these major utility projects. And certainly you need to not only watch for the equipment installation requirements, but ultimately the compliance requirements that will go with the permit, because we've seen with other MACT standards there's lots of traps for the unwary in how the permits are written. On the non-utility side, obviously those who are customers of utilities, there's the potential for rising electric rates to compensate for these controls or replacement energy sources. And as any consumer of a product, you should understand these cost increases and the timing, and one would want to look at your review of energy efficiency projects and factor in potential new costs, so that projects which might not pass a test now based on a higher electrical cost would pass a test, and you might want to undertake those projects at the current time. With that, I'm going to turn it over to Brian. He can look at the other part of the utility rule making, which is the cross-state air pollution rule.
Thanks, Mark. During my portion of the webinar, I'm going to discuss the EPA's new cross-state air pollution rule and the Supreme Court's recent greenhouse gas decision in the American Electric Power versus Connecticut case. The cross-state air pollution rule, which I'll call CSAPR for lack of a better acronym, used to be called the transport rule when it was proposed, and it replaces the Bush administration's Clean Air Interstate rule, which was overturned by the D.C. Circuit a few years ago. And that's important. As Mark pointed out with the MACT rule, the D.C. Circuit set a timeline for EPA to both propose and issue this final CSAPR rule. And oftentimes when that happens, practically EPA doesn't have enough time or is rushed, and therefore there's often lots of errors in both the proposed rule and the final rule, and we definitely saw that with the proposed rule, and I would expect to see that with the final rule also as people start to dig into the details. The final rule is 1,323 pages, if you're keeping track. The authority that EPA is relying on in issuing CSAPR is known as the Good Neighbor provision of the Clean Air Act, which is located in Section 110. The Good Neighbor provision requires states to prohibit emissions that, quote, contribute significantly to non-attainment in or interfere with maintenance by any other state. And this was the same provision that EPA relied on for CARE and that the D.C. Circuit overturned CARE based on. Basically, EPA is supposed to be looking at the contributions of states to other states' air quality problems. The CSAPR Timelines, it was finalized on July 6th. It was published in the Federal Register just a couple days ago on August 8th. That date of publication in the Federal Register is the important date to remember if you want to appeal the rule. You have 60 days from August 8th to appeal to the D.C. Circuit. Now, most rules, especially rules this big that EPA issues, usually have a 3-year compliance date from the date that the rule is finalized by EPA. And this rule is much different in that its first phase is January 2012. So the first phase of compliance is January 2012, which is obviously about 6 months from now. And the second phase, sort of the ratcheting down, is 2014. And because of that short timeline, it has caused a lot of issues in both how EPA has had to draft the rule and likely challenges that we'll see. So the CSAPR programs, there are 3 programs, 3 allowance trading programs or allowance programs. SO2, annual NOx, and ozone season NOx, which EPA has defined as being from May through September. Now, when deciding which states to include, again, EPA looked at the contribution of one state to another state's air problem or attainment problems, and they focused on basically 3 air quality standards when doing that: the annual PM2.5 standard, the 24-hour PM2.5 standard, and the 8-hour ozone standard. CSAPR covers, generally speaking, electric steam units that are greater than 25 megawatts in size. EPA has quantified that at 3,632 units in the states that are covered. As I said, sort of the first step in EPA's rule is determining which states are covered by CSAPR, and again, that was based on the impact to other states. EPA found that 27 states were covered by one or more of the programs. 23 were in the SO2 and annual NOx, were in SO2 and annual NOx states, and 20 were ozone season. And so there's obviously some overlap. Some states might be in all 3, some in 2, and some in just 1. In the new rule, EPA has also proposed to include 6 additional states in the ozone season NOx, so that was not in the proposed transport rule, and they plan to finalize that action by October. So those 6 states should expect to participate in the May 2012 ozone season program. So how does CSAPR work? Well, I mean, it's like any other trading program, although there are some significant differences that limit trading. So as with any other trading program, allowances are allocated to sources on a yearly basis. Emissions from those sources at the end of the year, the sources have to show that they have enough allowances to cover their annual emissions, and if they don't, there are penalty provisions. Now, under CARE, sources were allowed to trade freely with one another, basically with anyone within the CARE region. Now, trading is much more limited under CSAPR because for SO2, there are 2 groups. So the state's been broken out into 2 groups, which I think there's 14 or 15 Group 1 states, and the rest are in Group 2. And those sources in those states can only trade with other sources in their same group. So basically, EPA has cut the SO2 trading region roughly in half. And the designation of Group 1 or Group 2 was made based on the contributions of those states. So all the other programs, the trading is within everyone, within all the states, and it's not split in half, but for SO2 it's split in half. So that's one limit on trading. The other very significant limit is that EPA has proposed what are known as assurance provisions, which essentially are caps on the state's emissions. And so if the state goes over its cap, sources that go over their individual caps by, buying allowances from someone else can be penalized and would have to retire 2-to-1, 2 allowances for every allowance over allowance over their cap. And I'll get in a little more detail about that. But so the guts of the CSAPR program, and I think what will be likely to be the focus of any challenge, is how EPA set each state's emission budget. And as I said, sort of the first step was determining, well, what states are actually part of the program. And it did that based on figuring out what each state's contribution was to other states. And so there are actual numbers in EPA's, in the final care rule, there's tables that show you the contribution of each state. And they used cutoffs to determine which states would be in and which states would be out, so minimum levels of contribution. But when they went and they set the emission budgets, EPA did not base the emission budgets on those contributions. And instead, they started with the projected base case emissions in 2012 and 2014 for a particular state, and then they applied all these various cost thresholds, or they called them cost curves, to determine what each state's budget would be. And I'm showing you in the slide the two that they've chosen, which was $500 a ton for all of the programs, but $2,300 a ton for SO2 Group 1 states in 2014. And I guess to give you an example, I'm in Wisconsin, so I'll use Wisconsin as an example. And I don't know what the projected base case emissions were for Wisconsin because they're not listed in the table. But let's say they were in the 90 to 100,000 tons of SO2 in 2014 range. The way EPA set the budget for Wisconsin in 2014 was by looking at the sources in Wisconsin and saying if we applied controls on those sources up to the $2,300 per ton figure, what would the emissions look like after we did that? And they determined that it would be 40,000 tons. And so that's how they allocated or they chose the state budget for Wisconsin and all the other states. Well, there are legal and equitable problems with that approach. From a legal standpoint, it's not clear how picking these cost curves really abides by the D.C. Circuit's opinion in the CARE case, because it's not really measuring what the contribution is, or not really based on what the contribution is from one state to another, and is instead based solely on really which states have the cheapest plants to control. And then from an equitable standpoint, a trading program generally, the idea is that a source would put on controls, and the sources that could put on the controls the cheapest would put them on and then sell their excess allowances to the sources that are more expensive to control. Well, here what EPA is doing is essentially taking away those allowances at the beginning from the sources that are cheaper to control and giving them to the sources that are more expensive to control. So it's a windfall for the states with sources that are more expensive to control, and it really penalizes the states that have sources that are relatively less expensive to control. So there are both, I would expect there to be some challenges on that issue. Turning to the assurance provisions, this again is the cap that EPA sets for each state. It's not the budget number. So as I said, with Wisconsin, it was 40,000 tons in 2014. They realized that there is some variability in power production that's not related to emissions, so weather and other things affect how much power is needed. So what they did was they went out and they looked at the variability in all the states, and they used heat input to do that, and they figured out, well, what's the highest sort of difference, and they came up with 18% for SO2 and annual NOx and 21% for ozone season NOx. And then so basically they set the caps by adding 18% to the budget amount. So for Wisconsin, again, it was 40,000 in 2014, so the cap in 2014 is 47,349, which is 18% more. Again, there are penalty provisions that kick in if the state exceeds its cap, and then what the EPA does is they look for the sources that exceed their budget plus 18%, or their allocations plus 18%, and then they penalize those sources. So from a practical perspective, now sources not only have to know what their own emissions are and make sure that they have enough allowances for their own emissions to equal their own emissions, but they also have to monitor the state-wide emissions and make sure that the state doesn't exceed the cap. And from a practical perspective, that can be difficult because you know, utilities don't always know what other utilities are doing with regards to emissions, at least not on a real-time basis. So implementation and allocation, as I said, this rule is being implemented very quickly in 6 months, and because of that, EPA has set federal rules that will apply across the board in 2012. So everyone will have to abide by the federal rules, which are known as the FIP. States, as of 2013, can start adopting their own rules, or SIPs, but you know, practically speaking, it usually takes 2 to 3 years to do that. So there may be states that wait until the 2014 compliance deadline to have their SIP kick in. There's no carryover of acid rain, NOx, SIP call, or CARE allowances into this program. The unit allowance allocations are based on the historic heat input. So you look at what the state's budget is and then divvy out the allowances to the sources in those states based on their historic heat input. There are new unit set-asides that are on a state-by-state basis, and they're up to 6%. So they set aside allowances for new sources. And the state SIPs can differ on allocation methodology. So I would expect there to be lots of discussion at the state level about whether or not to follow EPA's allocation methodology. So as I've said, I mean, as with any big rule, challenges are likely. Many states and sources are unhappy with their budgets. They're ratcheted down significantly more than CARE in many instances. And some states, because of the way EPA has done it with the cost approach, actually came out better than CARE. So I would expect some states to challenge the rule. Again, arguably, the EPA's proposal doesn't comply with the good neighbor provision, which is the exact reason CARE was overturned. Utilities have commented that EPA doesn't have this FIP authority, so in 2012, requiring everyone to comply with federal rules, the utilities have argued that, in fact, they can't do that and they have to give the states the ability to adopt a SIP. And a lot of utilities have argued, again, that the timelines are unreasonable and unworkable. There was lots of arguments in the comments about how long it would take to install this control technology. EPA was saying 30 months would be the longest, and utilities were disagreeing with that. I guess the last point is that this rule, as with any EPA rule, could end up being stayed, especially because it's on a shorter compliance deadline, although that's not the norm. Usually the D.C. Circuit will let the rule go forward and then decide later. So turning to the Supreme Court's greenhouse gas decision, American Electric Power Company versus Connecticut, various states, the City of New York, and environmental groups sued the 5 utilities that have the greatest emit the greatest amount of CO2 emissions in the country. So that's how they picked the 5 utilities. And they claim that the utilities' CO2 emissions constituted a public nuisance. And they asked the court, and this is important, the relief that they sought wasn't money, but it was that a CO2 cap would be applied to the plants and ratcheted down annually. So the Supreme Court addressed two issues in the case. One was whether the plaintiffs have standing, and the second was whether the Clean Air Act displaces the plaintiffs' claims. And the Supreme Court ultimately dismissed. On the standing question, the court really didn't talk too much about standing, although it did address it. Standing generally requires a substantial interest in the outcome of the case. And the Massachusetts versus EPA case, which was the greenhouse gas case that the Supreme Court decided a few years ago, addressed standing. And in this case, basically the judges split 4-4 because Sotomayor had recused herself. So essentially it was a tie. And because it was a tie, the lower court's decision is automatically upheld, and therefore the plaintiffs had standing. They really didn't get into too much analysis on the standing issue. I think it was at most 2 or 3 paragraphs of the decision. The Clean Air Act displacement issue was the big issue addressed. And while this case got a lot of press, the holding itself is pretty narrow. The plaintiff's nuisance claims were based on federal common law. And the prior Supreme Court precedent was very clear that federal common law claims disappear when the issue has been addressed by a congressional statute. Well, if you remember the Massachusetts versus EPA case, in that case the Supreme Court found that CO2 was subject to regulation under the Clean Air Act. And since then, EPA has been working on CO2 rules for power plants. So based on those two things, the court in this case held that the Clean Air Act and the EPA's actions displaced the federal common law nuisance claims seeking CO2 abatement from fossil fuel-fired plants. And really, I think, as I pointed out at the beginning of talking about this case, the critical mistake, so to speak, that the plaintiffs made was asking for CO2 caps on the plants, because that is so directly in line with what EPA and the Clean Air Act cover and are doing, and the things that EPA is working on. So it was pretty easy for the court to find that the Clean Air Act displaced the federal common law of nuisance in this case. Now, the court did not decide whether state law claims are preempted by nuisance, but I would expect there to be a lot of litigation on that issue. And with that, I'll turn it over to Dick to follow up on CSWE and the Boiler MACT.
Okay, thanks, Brian. If you were here for our February web conference, you got a full dose of these brand new regulations, the CSWE and Boiler MACT rules that had just come out a day or two before our conference, our web conference. And there's been a lot that has happened. Some of what happened is typical for new rules. I mean, you've heard through Mark and through Brian that all these major new rules now, they get subject to judicial review, they get subject to administrative petitions for reconsideration, stay issues come up and all that kind of stuff. So some of what has happened is typical. Some of what has happened, though, is not that typical. In the second bullet there, I noticed that, and this is important, when EPA issued these final rules, now again for CSWE and Boiler MACT, and by the way, you'll see the Federal Register sites. The last time we met, we didn't even have it in the Federal Register yet, so now they all got in the March 21st Federal Register, and there's the sites for you. You'll remember perhaps that simultaneously with the issuance of these final rules, EPA also said, hey, we're going to reconsider them. Now, that is unusual. They've done that once or twice in the past that I can remember, but that's pretty unusual that they, in effect, say they're final, but we're going to reconsider them. And the main reason they did that is because they had been under an incredibly short leash court order to issue those final rules in a federal district court here citizen suit case brought by Sierra Club. Typical, again, there had been several extensions, and there had been extensions over a couple of years, and EPA kept trying to do these rules. They finally went back to the judge here last December and basically said to the judge in the federal district court, in order to do this responsibly, we need about 16 more months because we really do need to repropose. And the judge sort of threw up his hands. The Sierra Club went wild and basically said this can't go on forever. And the judge basically sort of, maybe a little bit like Pontius Pilate or something like that, it basically just said, I've had enough. And you've got EPA, he gave EPA one more month when they said they needed 16. So, and everybody knows anything about these rules knows that they're just an incredible mess, just all sorts of problems with them. And EPA recognized it too, so they announced the reconsideration. Okay, so again, the first couple of things I've got here noted are that's pretty typical is that all sorts of parties have filed administrative petitions for reconsideration on both these rules with EPA. They're pending. All sorts of parties have filed petitions for review in the D.C. Circuit, and those are pending. What is unusual, in addition to this sort of automatic voluntary reconsideration, is that EPA has announced now, and this is in the May 17th Federal Register, they've announced an indefinite stay of the effective date of CSWE and boiler rules, pending the administrative reconsideration and the judicial review. Now that is pretty unusual that they would do that. Now they did that in response to some industry petitions, but they also actually had broadly hinted that they'd probably do that anyway at the time they went final with these rules. They indicated that in some letters to Congress. And by the way, members of Congress have been all over these rules as having awful dramatic economic impacts. So EPA has tried to be sensitive to that. So anyway, even though they didn't tailor the rules themselves out of any concern for that, they're, at least by the stay, maybe they're showing some sensitivity. So now EPA, because they have not only stayed the rules but also announced this big reconsideration where they're going to go through a new rulemaking, they have asked the D.C. Circuit to hold all this judicial review in abeyance, which makes sense because normally if you know the rule is going to change anyway, probably through new rulemaking, maybe it's a waste of time to go through judicial review on it. Now here comes the Sierra Club again, though. The Sierra Club is strongly objecting to EPA's request to hold all this stuff in abeyance in the court, and they're strongly objecting to EPA's indefinite stay. What they are saying, and perhaps there's some logic to this, is that EPA had gone to the district court in December and asked for about 16 more months to go through a new proposal and then go final. And the judge said, no, this time's up. This has gone on too long. You must issue these within 1 month. Well, the net effect of what EPA is trying to do now is basically the same thing. The net effect is that they've indefinitely stayed the rules, and they said they're going through a new rulemaking. Now, by the way, and what the Sierra Club has already come back in a pleading in the D.C. Circuit in objecting to the request, EPA's request for the indefinite stay of the litigation, is that they have a theory that EPA's stay cannot go beyond 3 months. And if they're correct, that means the stay would end 1 week from today on August 18th, 2011. Unfortunately, their theory is not cockamamie because there are definitely words in the Clean Air Act itself which might be read to suggest that when EPA issues a stay pending reconsideration, it's limited to a 3-month period. In fact, that's sort of what it says. EPA knows that, and of course, they tried to, foreshadow that and try to protect against that, because when they issued this indefinite stay, they also said they were doing it pursuant to the Administrative Procedure Act, which does have, during judicial review, gives agency broad authority to stay the effect of a rule or to hold a rule in abeyance. Now, the Supreme Court is going to be arguing that the Clean Air Act language trumps that, and it's never really been thoroughly litigated before, so interesting stuff's going to happen there. Now, EPA has announced, in order, I think, to head off some of these Sierra arguments, they've at least announced a pretty expeditious schedule for how they're going to do this reconsideration. And you'll see there what they've told the D.C. Circuit, and then they followed up with a press release on the same day, is that they want to do new proposed CSWE rules and boiler MACT rules by the end of October of this year, and then finalize them by April 2012. Again, quite ironically, that is exactly the schedule they asked the federal district court for and were rejected on. Now, the Sierra Club has reviewed those dates, and they're not happy at all, and they're going to pursue that. And everybody should be aware of this, that what's happening now is that the Sierra Club has gone back to the federal district court. And by the way, I don't know whether this was luck or what, they drew the very same judge, Judge Friedman, who had issued the order commanding that these regs be issued by February no matter what. They got the same judge. They also filed a new, and they also went back to him in the old matter. They've got them consolidated. And they're going to try like heck now in the federal district court to get an order basically saying that EPA is in defiance of the judge's order, that they violated the Administrative Procedure Act and everything else when they did this indefinite stay, and also that EPA is limited to 3 months anyway, and they're going to try to get that federal district judge to put EPA back, in other words, to require EPA to lift the stay. And again, under their theory, that could happen anytime after August 18th. And they have already filed their motions to do this. Now, the government takes the position, and I think most industry counsel think the government is right, that actually there's exclusive jurisdiction in the D.C. Circuit now because it is a final agency action, and the Clean Air Act puts final agency actions under the Clean Air Act into the D.C. Circuit, but it's a mixed question. So the Sierra Club has filed there protectively also, so we're now sitting with motions pending in the D.C. Circuit and in the Federal District Court all addressing this, and it's going to be a little bit of a jurisdictional fight for a while. But everybody should know about this. Now, again, because if Sierra prevails, again, this stay could be lifted. Now, some people, right now, you may be wondering, is this really a very big deal for right now? The Boiler MACT rules don't kick in for 3 years anyway for existing sources. The CSAPR rules don't even kick in for 5 years for existing sources. So why be excited? Well, if you're only worried about Boiler MACT, there's some force to your arguments unless you've got a new source online coming. But for CSAPR, it's really different. CSAPR and MACT are very different in the way they approach existing sources and modifications. Under MACT, an existing source can increase emissions, and it won't become a new source. It won't become a new source unless it, quote, reconstructs or really does build a greenfield new source. That is not the way it works under CSAPR. Under CSAPR, if an existing source has an increase in emissions, and EPA's regs are terribly vague right now on what kind of increase, then you can trigger new source, and the new source stuff is effective immediately. So what this means is, you'll see in my last dot there, that the way the CSAPR regs are now written, that anybody that increases emissions after September 21st can become a new source under CSAPR. I think most people who know CSAPR know that the new source standards are impossible to meet, and therefore this is something to worry about. So I would encourage you, if you're now combusting anything that has been defined as a solid waste that would make you a CSAPR source, I would encourage you to watch what's going on with this Sierra Club action in the D.C. Circuit and or in the Federal District Court. And by the way, industry people are intervening in those matters for sure. Now, I also wanted to cover briefly a new case that came out in June in the D.C. Circuit, which many people thought was going to have a couple of extremely significant rulings on some precedential issues in the MACT area. In fact, you'll remember that Mark was talking about the pollutant-by-pollutant approach, and Mark was talking about how critical some of these issues are. And anyway, so what happened was we had the Medical Waste Institute case that was decided by the D.C. Circuit on June 24th, and very closely watched, and particularly on a couple of issues having to do with MACT floor standards. Now, remember here, and this is kind of critical to the way these issues can become so significant to the standard setting process. You know, the MACT is, for existing sources, it's a two-step process. You have floor, which is based on the best 12% and all that kind of stuff, and then you have beyond the floor. But the floor, which is based on the best 12%, does not consider cost. The statute is quite clear on that's regardless of cost, you have to do what the best 12% are doing, and then EPA can go beyond that, beyond the floor, if it goes through a cost and a benefit type of analysis, considering cost effectiveness and non-environmental quality impacts, all those kind of stuff. So the three issues that came up in this Medical Waste Institute, because EPA had issued some new major regulations on hospital and medical waste incinerators, which were quite tough. just about a year ago. And this was, again, this is as everybody's talked about today, when you get in these rules and you get in the D.C. Circuit, the D.C. Circuit reverses things, and then years later they come back again, and then they get reversed again, and so it's sort of a never-ending cycle. So this is one of these where, you know, years after the D.C. Circuit had rejected EPA's approach for medical waste incinerators before, they're all back before the court again, and the incinerators are trying to get judicial review. The three issues that people were watching are something called MACT-on-MACT, pollutant-by-pollutant, and startup, shutdown, and malfunction. MACT-on-MACT, we've got a slide on that. Here, and again, consider the fact that EPA starts issuing regulations, then they get thrown out by the court, or they at least get remanded by the court, and they come back, and then EPA has to comply with with the court order, so they issue new regulations a few years later. Well, what about the situation where if you're supposed to be based on the best 12% of your cohorts, what if, you know, years ago EPA came up with a number based on the best 12%, then it had to redo it, and in the meantime a lot of sources actually tightened up. So a lot of sources would be, you know, in compliance with those standards or for other reasons, a lot of sources would start actually meeting much more stringent emission standards. And then EPA does it again. Well, now do they look at this new group, I mean, and at the sources meeting these new standards, and take the best 12% again? You can see that as a matter of logic, if they did that very many times, there'd be nothing left. I mean, the emission levels would be zero because you keep doing 12% on 12% on 12% over the years. So that was one issue that the industry raised, in that they were claiming that EPA had done a MACT-on-MACT approach on them, and then that was illegal. The other issue that is even perhaps more closely watched by industry and is a real big deal in the utility MACT cases that Mark was talking about, and it's also a very big deal in the CSWE and boiler MACT cases, and it's also a very big deal in other cases pending right now in the D.C. Circuit, like the Portland Cement NESHAP MACT, is pollutant-by-pollutant. Now, here the issue is, as you know, MACT usually covers several pollutants, and if you have this sort of best 12% rule, then are you going to set the ultimate standards on the floor for, you know, each pollutant? That, in other words, do you find who is the best 12% for pollutant X, and then who's the best 12% for pollutant Y, and who's the best pollutant, best 12% for pollutant Z, and then do you set those standards, you know, that way, regardless of whether these sources are meeting low standards for the other pollutants, or do you try to get the best 12% of the sources overall, considering all these pollutants, which is called the source-based approach? EPA has used the pollutant-by-pollutant approach in the past, although I want to qualify that in a minute by saying it had a different function in the way EPA did things. And the environmentalists, of course, have always supported the pollutant-by-pollutant approach. Bottom line is, but just to cut through some of this because it is kind of complicated, if you use pollutant-by-pollutant approach, if EPA does, it means much tougher floor standards. And one of industry's main arguments is that the more EPA does this and the more standards get stringent on the floor, which you don't consider cost, then they're sort of reading the beyond the floor stuff out of the statute, because EPA never has to go beyond the floor and start thinking about, you know, cost and benefit, because the floor standards are already so ridiculously low. So anyway, and then the final, the third basic issue, I'll cover this very quickly, was the startup, shutdown, malfunction, where, and most of you know about this, that EPA had proposed to include startup, shutdown, malfunction exemptions in the reg for the incinerators. The D.C. Circuit threw out EPA's legal theory on how that could be supported in an unrelated case while the rule was pending. Then EPA went final by taking out the SSM exemption, even though they hadn't proposed to do so and never gave public notice on it. And so the incinerators sued on that issue, basically saying they had no notice and comment. They never got a chance to try to distinguish that other case or anything else. Okay. So we get everybody was watching for this opinion. Everybody was waiting. The D.C. Circuit usually takes 3 months these days to issue an opinion after oral argument. 3 months went by, 4 months went by, 5 months went by, and everybody's wondering, whoa, you know, they must be writing quite an opinion here. Well, The final result came out on June 24th, and is actually quite disappointing because they essentially ducked. They used the D.C. Circuit used some neat little judicial ducking mechanisms to not even address two of these issues. And frankly, MACT-on-MACT was a little bit of a duck because they basically said that the first round, what EPA did to set standards was so deficient that it really wasn't MACT anyway. So the theory that the industry put forward on MACT-on-MACT just didn't apply. So that's the ruling we got on that. On pollutant-by-pollutant, and I got to tell you what the court did here is bothering a lot of people in industry all over town here, and all industry council and so forth. They basically said, oh, we're not going to address that issue now because EPA had argued, and the court bought this argument, that when the incinerator people, the hospital incinerator people, were before the D.C. Circuit 10 years ago, EPA had used a form of a pollutant-by-pollutant approach. And they didn't raise it then, and there is this 60-day preclusion thing in the Clean Air Act. And so the D.C. Circuit said, well, you're just too late. We're not even going to consider that on the merits anymore. You could have raised this argument 10 years ago. You didn't. Too bad. Now, just so you know, that ruling has incredible implication for a lot of other industries right now that are going to be before the D.C. Circuit in the next couple of years. Because, again, a lot of industries are in the D.C. Circuit based on a second or third round of rulemaking, where maybe they could have raised an argument before and didn't. The problem is, on a lot of these cases, 10 years ago, even though you could have raised an argument, you didn't because it didn't make any difference. The fact that EPA had used a pollutant-by-pollutant approach 10 years ago for these incinerators, or like 10 years ago, for instance, for Portland cement kilns, because of other ways that EPA calculated the floor, the pollutant-by-pollutant approach simply was sort of irrelevant and it didn't hurt. And so, therefore, if it didn't hurt, generally you don't sue. In fact, there's some interesting issues of standing. Even could you sue? The court didn't even seem to think about that, and they just basically. And by the way, there's a petition for reconsideration that has been filed as of 2 days ago by the industry on this. And I got to tell you, again, industry people all over town are really upset about this and are going to try to get the D.C. Circuit to reverse itself on that, or every time now we have a new MACT case in the D.C. Circuit, we're going to have to find that we're going to have to distinguish ourselves or try to get the court to cut back on that logic. Again, on startup shutdown and malfunction, this time, instead of judicial preclusion, because they could have raised it before, the court held that the hospital incinerator people waived their right to challenge that because there is a provision in the Clean Air Act that says that any argument that you could have made during the rulemaking but didn't, what you're supposed to do is file an administrative petition for reconsideration with EPA before judicial review will proceed. The hospital incinerator people didn't do that, and they say, well, therefore you're out, you can't litigate that. Now, again, that was kind of ridiculous, a lot of people think in the industry, because it was so obvious that EPA had fundamentally violated the Administrative Procedure Act and knowingly and deliberately did not propose to take SSM out before they went final, that it would have been just silly to have gone and filed one of these administrative petitions for reconsideration, and that would have cured it anyway. So again, there's a lot of hand-wringing over this particular result in the D.C. Circuit's medical waste case. And again, I think I already said this. Yeah, so the medical waste, both the main parties and the interveners did file petitions for rehearing with the D.C. Circuit on August 8th. And as you might know, those are usually low percentage moves, but there's a lot of hope there that maybe the court will come to its senses on a couple of those issues. So, Mary, should I turn it over to you now to see if there's any questions coming in by phone?
Ladies and gentlemen, if you do have an audio question, please press star then 1 on your touch-tone telephone. Again, if you do have an audio question, please press star then 1. I'm not showing anybody queuing up for a question.
Okay. I guess we explained everything so well. Anyway, so it's about time you get off. Remember that you can go on the web here in just a few days. There's the link. Tell your friends who may have missed it that they can go on in a few days and listen and watch this whole thing again. There's your contact for any CLE questions, Jennifer Bartz. Again, you can print this right now. And also, if you have time, please, we do value comments, particularly what we've reacted to and tried to accommodate is some of you have been very good about suggesting topics that you're very interested in, and there's a place on this form for you to suggest topics for future web conferences, so we definitely encourage you to do that. So thank you very much, and I'll be talking in another 3 or 4 months.